Good afternoon. May I call the registrar? Ask the registrar to call out the case number.
The Prosecutor versus Dragoljub Kunarac, case number IT 9623I.
Thank you. May I have the appearances, please?
Your Honours, for the prosecution, we have here Patricia Sellers-Viseur and Hildegard Özretzlaff.
Your Honor, I'm Igor Pantelic, Defense Counsel on behalf of Mr. Kunarac, and I'm acting in accordance with the authorization of my colleague, Mr. Prodanovic, who is not able to be present here today. And I suppose that trial chamber have got his explanations and letters concerning these issues. Thank you.
Thank you. Mr. Kunarac, can you hear me? Can you hear me? Thank you. Be seated. We can now commence with this hearing. Now, as you know, this is the third hearing of the adjourned initial appearance of the accused before the International Criminal Tribunal for the former Yugoslavia. As the parties are aware, the trial chamber issued an order after the second hearing in the initial appearance of the accused on Tuesday, the 10th of March. And the order rescheduled the continuation of the initial appearance and ordered Mr. Prodanovic to appear before the trial chamber. At that time, I'm reading out the order, having made adequate provision for prior consultation with his client, and he was ordered to explain to the trial chamber the circumstances of his absence from the hearing, failing which the trial chamber would consider instituting proceedings for contempt. Now, the trial chamber has since received a defense motion filed on the 11th of March in which Mr. Prodanovic lists objective circumstances which prevent him appearing this afternoon. In that letter or motion, he suggested that the accused might be represented by his colleague, Mr. Pantelic. Now, the trial chamber takes this matter very seriously for three reasons. First of all, Mr. Prodanovic absented himself from the last hearing without leave of the court, and after having formally agreed to that hearing taking place. I remember that I asked him whether he would be available on Tuesday afternoon at 4:30, and he said yes. The next day, in any case, after the first hearing. Second reason is that Mr. Prodanovic failed to consult with his client following the first hearing and prior to his departure from The Hague, so leaving the accused without legal advice at a crucial stage in our proceedings. And the third reason is that the tribunal has not been informed of any apology received from Mr. Prodanovic. Now, the trial chamber now looks to his colleague, Mr. Pantelic, to explain these actions by Mr. Prodanovic. Mr. Pantelic.
Thank you, Your Honor. First of all, I am also fully authorized on behalf of Mr. Prodanovic to give to this honorable trial chamber all his personal highest apologies about this inconvenient situation, and also he has authorized me to inform you in some details how was the development of this situation. So briefly, I would like to bring to your attention some important facts towards this issue. Late in the evening on Monday, 9th of March, my colleague has got some very important and very urgent messages from Foca, and as well as in the morning of March 10th. These informations are fully related to this particular case and also with some of the other co-accused in this case. And in the morning of March 10th, before our conference with the members of OPT, my colleague informed some of members of the registry in my presence about this, let's say, extraordinary circumstances. During our conference with Office of Prosecutor, he and me, we also informed the prosecutor about these new events. And finally, immediately after this conference with OTP, he was in situation to inform again the registry and to kindly ask to inform the trial chamber about these new events, having in mind that this is the most urgent and appropriate way to inform trial chamber through the registry. And furthermore, Mr. Heinz, Deputy Registrar, around 1 o'clock on March 10th, spoke with me personally about all this issue, because my colleague Prodanovic is not English speaker, so I was acting on his behalf, and I briefly explained to Mr. Heinz the reasons and the circumstances why Mr. Prodanovic was obliged to leave The Hague before this second part of initial appearance, according to Rule 62. Also, at this point, please let me stress that I saw this internal memorandum sent by the registry to this trial chamber, and where the one expression was that Mr. Prodanovic was obliged to leave The Hague in order to have some conferences in Belgrade with his clients, which is factual error, because this conference took place in Foca, in Serbia. However, I have some other explanations which might be very, very important to this trial chamber. And in this light, I think this trial chamber will be satisfied with all this explanation. But because of the nature of these informations, and because of the some kind of level of confidentiality, I would prefer if it would be possible to do that in closed session, maybe after this hearing or in some other appropriate time, because that was one of the requests of my colleague, Mr. Prodanovic, having in mind the sensitivity of these issues.
All right. First of all, as with regard to the behavior of your colleague, Mr. Prodanovic, as we said before, we will make a formal report of his behavior
Your Honor,
these events to the registrar.
Should I state, or can I sit? Yeah.
As you wish, to the registrar. And yes, no, I will. I'm going to ask you a question. Now, what you just said you would like to explain to the trial chamber relates to the guilty plea.
No. It's just in relation with the motives and the circumstances about his sudden departure from The Hague, which might be also important for this trial chamber. Just to have, in general, a picture of this nature.
But has nothing to do with the plea.
Nothing, Your Honor.
All right. So it will be done afterwards.
Yeah,
then let us
just
now.
For your information. Yeah.
Good. Move on to the question of the plea, and I would like to ask the prosecutor whether they can are now in a position to set out their position in regard to the outstanding counts in the indictment, counts 40 and 43. The counts other than the one, count 41, on which the accused has already taken a stand.
Your Honours, the prosecution has spoken with the accused in the presence of his counsel and with the defense counsel separately as well, to determine the factual basis of the charges to which the accused has pleaded guilty. The prosecution was not satisfied with the underlying facts stated by the accused in his interview in regard to the charge. While the prosecution has been willing to exercise flexibility to determine the factual basis of this plea, in order to conclude the initial appearance of the accused, We must inform the trial chamber that we are not prepared to concur with defense counsel or the accused, and we are also not prepared now to drop any of the charges. We would ask the trial chamber to set a date for a status conference in which the future trial preparation can be discussed. We appreciate very much the time and attention that the trial chamber has granted to the prosecution and the defense to settle this pleading. Your Honors, the prosecution stands now ready for trial.
Well, thank you. What you said applies to which counts?
It applies
40?
to 41, to the guilty plea, and also to the other charges. We are not dropping any charge now.
Not even count 42, based on grave breach, torture as a grave breach.
That might be on a later stage, but not today.
All right. So we have now to, actually deal with the question of the plea to count 41. All right. We have to clarify the question of the guilty plea made by the accused with regard to count 41. And because, as you know, under our rules and procedure and evidence, Rule 62 bis, if an accused pleads guilty, the trial chamber must be satisfied that the guilty plea has been made voluntarily, the guilty plea is not equivocal, and there is a sufficient factual basis for the crime and the accused participation in it, either on the basis of independent indicia or of lack of any material disagreement between the parties about the facts of the case. So therefore we have to see to it that this provision is applied with regard to count 41. First of all, the facts to which the guilty plea applies. Mr. Pantelis.
Your Honor, in support of the facts that we just heard from the prosecution side, I would also inform you that in order to clarify my client's mental relation and his conscience concerning the all facts regarding to this plea, I would say that after the analysis that we've made, I would say that we were faced with some kind of legal Rashomon situation. That means that Mr. Kunarac pleaded guilty because he felt that he know that very well that he committed some crimes. But these crimes are obviously not related with these charges and with this kind of qualifications. So during this morning interview with the prosecutor office, he openly, with his free mind, open mind, explained all factual basis and all details concerning his mental relation to all these issues. And now I think it would be appropriate way to hear maybe another explanations from Mr. Kunarac, so that we can proceed with the other steps in this our relevant procedures. And as prosecutor stated, we are as a defense ready to have another status conference with all possibilities of possible withdraw some charges or maybe some clarification, because the main issue while we were discussing all these legal moments, was that some paragraphs were related to his prior behavior during the 92, but it was not related in general with the qualifications made by the prosecutor. So that was the main, as I can say, disagreement or some kind of, well, say non-clarification of some issues. And I would strongly suggest that we can maybe hear Mr. Kunarac what he can tell us with regard to these issues.
Yes, thank you. Yes, because, you know, after carefully studying the indictment, it has become clear to the trial chamber that to enter a valid plea, the accused must be aware that he's pleading guilty to the various allegations listed in the indictment, and I would refer to various points. So I will ask him various questions, and he should reply whether or not he's pleading guilty with regard to the various allegations. Because as counsel, of course, defense counsel is aware that the charge of rape is based in the indictment on various provisions. Article 7.1 of the statute, direct participation in rape. 7.1 of the statute again, but in a different respect, allegations of aiding and abetting rape. 7.3 of the statute, namely allegation that he is responsible as a commander for the rapes committed by subordinates. And again, and then under Article 5, rape as crime against humanity, widespread assault, rape as a part of a widespread assault on the Muslim population of Foca. So we have to make clear that the accused is entering a plea with full knowledge of the implications of this guilty plea. We will first of all now ask the accused to specify these various points, and then I will turn to the prosecution to ask a question about the factual basis of the various charges. There's one point which is not very clear, at least to me, namely whether the charges of torture, rape, and the various other charges, torture, rape, torture, they are all related to the same factual basis, whether the same facts have been classified by the prosecutor in their charges against the accused as torture and rape. Let us start with the prosecution then.
Honest, that is just what we mean. All of the charges based on basically on the same facts. We see these charges accumulative. That's how we will do it. The only is there are some legal differences in the different charges, but basically it's the same facts, of course. And we understand from the merits. We understand that he himself is involved in the rape of 5 women, especially here described in the various chapters, 7.1 clearly. As far as he himself took women, for instance, to these various places, rape locations, we also see clearly 7.1. And in regard of these cases where the men took out the women without his presence, then we consider 7.3.
Thank you. I wonder. That means, if you don't mind, I would like to insist on this point. Say, for instance, the count 40 is crime against humanity. Count 41 is again crime against humanity, and there Crime 40 is crime against humanity, torture. Crime 41, crime against humanity, rape. And this double classification is related to the same facts. And again, then you have put forward the charge of grave breach, torture, and war crime, count 43, again for the same facts, which you in this case label, as it were, classify as torture.
Yes.
Thank you.
And the difference is, of course, international armed conflict and just armed conflict.
And you said before that you have not yet now decided whether or not to drop the count 42 on grave breach.
We would like to do that after the status conference.
Thank you. Thank you. Now we are in a position, I think, having clarified the position of the prosecution, to move on to the guilty plea of the accused. And as I say, first of all, under our rules of procedure, the guilty plea must be made voluntarily. So I would like to ask the accused to stand up and to answer my questions. Yes, Mr. Kunarac, did you make this plea voluntarily? No one has forced you to do so?
Kada sam rekao da se osjećam krivim, da sam kriv, to sam rekao jer sam tako osjećao. Moralno i mentalno sam tako osjećao i jedini, ako je neki problem ovdje, jedini je problem što ja hoću reći istinu zašto se osjećam. I to sam i rekao. Istina je da sam sudjelovao u jednoj radnji koju sam jutros na razgovoru sa tužiocem pokušao da objasnim zašto se ja osjećam krivim. I za ono zašto sam jutros izjavio da sam ja lično učinio, ja i sada ovdje pred vama tvrdim da sam kriv. Da se osjećam krivim u onome kontekstu u kome sam objasnio to jutros javnom tužiocu. U stvari ja sam pokušao da objasnim. Da li smo se razumjeli, ja ne znam. A ako to nije razjašnjeno, onda ja moram da slažem samog sebe i svoje osjećanje i da kažem da nisam kriv. Pa da u pretesnom vijeću, kada doživimo da se suočimo sa svim činjenicama, da tada ili tribunal i vijeće bude u situaciji da kaže da sam ja kriv ili nisam. U svakom slučaju ja želim da priznam sve ono što je moja lična krivica u svoj toj optužnici. Ne znam pravno kako to sve formališe s advokatom s kojim ja sam razgovarao i prije nego sam dao izjavu objasnio sam mu da neću da slažem jednom momentu ovaj tribunal i ovo vijeće ovdje. Došao sam dobrovoljno, došao sam svjesno, došao sam časno, pošteno da kažem šta je istina. Ja sam zato ovdje. Težina moje krivice je takva kakva jeste. Ja sam tu, procijenite moju krivicu i dajte joj pravnu odluku.
Thank you. Mr. Kunarac, my question was more specific. Did anybody force you to enter a guilty plea to a crime against humanity? Or did you plead guilty in a voluntary way?
Nije me niko natjerao da kažem da sam kriv.
Thank you. Thank you. Thank you. Now we have to move on to the second requirement set out in Rule 62 bis, namely that the guilty plea must not be equivocal. That means that you must be aware of the legal import and the legal implications of your guilty plea. First of all, as I mentioned before, you have been accused in the indictment with a crime against humanity and rape in various respects. First of all, direct participation in rape. Article 7.1 of the statute, and this is one point. Then you have been accused because it is claimed by the prosecutor that you aided and abetted in the commission of rape, 7.1 of the statute. Also that you have command responsibility because you were responsible as a commander for the rapes committed by your subordinates and you failed to stop your subordinates from committing rape. Are you aware of all these implications which are set out in the indictment?
Ja sam svjestan šta javna tužba, kako javna tužba ima sliku i kako je formirala tu optužnicu. Ja sam svjestan da je javna tužba u totalnoj zabludi šta se dešavalo na terenu u to vrijeme koje je bilo dole. Dakle, ako u tome duhu želite da dam izjavu i ako javnoj tužbi moje priznanje koje sam jutros pojasnio gdje ja osjećam svoju krivicu, onda ću ja morati u ovome slučaju da kažem da se ne osjećam krivi za zločin protiv čovječnosti. Jer ja nisam htio, kad sam rekao da se osjećam krivi, da sam kriv, u tome momentu kad se izjasnio, da slažem i da sakrijem svoju krivicu. Nego sam htio da kažem da osjećam krivicu jer ona postoji. To je činjenica, se desio čin koji sam jutros objasnio javnoj tužbi u intervju. I ukoliko to nije krivično djelo, zločin protiv čovječnosti u tim okolnostima u kojim se dešavao i tako kako se dešavao i sve to, onda sam ja bio u zabludi svoga izjašnjavanja. Nisam našao prostor u nijednoj tački koje se stavljaju protiv mene, 41, 2, 3 i 4, da kažem na osnovu koje se ja izjašnjavam krivim, gdje je taj moj osjećaj krivice, gdje ja sebe mogu da nađem. I onda sam u tome duhu sam uzeo taj, ne znam apsolutno pravno da li je najteži ili najlakši, ali tu se spominje samo silovanje bez primjene neke sile bilo čega, a u odnosu na okolnosti koje se desile, ja lično sam shvatio da je to ta tačka po kojoj mogu da se izjasnim i svoju krivicu. I ukoliko javna tužba odbacuje mogućnost da to moje priznanje nije adekvatno mome izjašnjenju, da ću morati da povučem svoju izjavu da sam kriv. Ne zbog toga što želim da bacam nekog u zabludu, nego i meni odgovara da uđem u kompletnu optužnicu, u kompletan pretres cijeloga događaja i siguran sam, poznavajući činjenice kakve su i što su, da je javna tužba u totalnoj zabludi.
Mr. Kunarac,